We've gone through a lot of trials, and it's been because of the poor choices of our oldest son, Josh. But the good news is that through all these trials, God has really drawn our family very close together. And I want to tell you, God's principles work. It's just, you know what, sometimes we don't apply them to our lives. And if we don't apply them, there's consequences. And that's what's happened with Josh. But yet,
Hey you guys, it's Katie from Without a Crystal Ball. Welcome back to my channel. The government says that Joshua Duggar is going to blame some guy named William Mize for being one of the people that might have downloaded the content on his computer. Remember how I told you about how Josh has been running around all over the town while Jim Bob and him have basically been saying that a shady ex-con or someone that they worked with that Josh trusted and shouldn't have given a chance were the ones that might have been to blame for what was found on Josh's computer. Well, now the government has filed a motion requesting to subpoena bank records before trial for someone that they claim Josh is going to blame. So they put in a request for a subpoena for bank records. And it says during the course of the investigation and in preparation for trial, the government has reason to believe that the defendant will attempt to introduce evidence that other individuals had access to the defendant's HP desktop computer at issue and therefore could have committed the offenses charged in the indictment. Based on previous filings submitted by the defense, the government believes one of these individuals the defendant may suggest is William Mize. The government has reason to believe that Mize was in Missouri during the relevant time frame at issue and is seeking bank records for confirmation. The government is requesting records from Regions Bank for any and all account information connected to William Mize, including but not limited to account ownership, and then statements from May of 2019 that reflect location and dates of all account activity, including but not limited to deposits, withdrawals, debit and credit memos, deposit slips, checks deposited, withdrawals, all credits and debits, the amount and the location of the credits and debits, deposit slips showing locations of transactions, date of transaction, and any all information related to deposit activity, and including withdrawals at ATMs or tellers and locations. They say that the records are relevant for the government case as they may affirmatively exclude William Mize from Wholesale Motors and the state of Arkansas on the dates in question. They say that the criminal procedures authorizes the court to direct a witness to produce the designated items in court before trial or before they are to be offered in evidence. When the items arrive, the court may permit the parties and their attorneys to inspect all or part of them. The government asks after the subpoena is prepared by the clerk's office that the Homeland Security Investigation Agent Howard Aycock be authorized to serve the trial subpoena on Regions Bank. Government requests the subpoenaed material be ordered returned to the court on or before November 15th, and they respectfully request that they permit the parties to copy the records that are obtained pursuant to trial subpoenas authorized by the court. So Josh Duggar's plan is to try to argue that somebody else was at his place and they're the ones that downloaded this from his computer. Sounds like William Mize is on the hot seat, and the government says they believe they have evidence that will show that he was in Missouri on the dates in question, and so they need those bank records. Interesting. 3 other people have already been excluded from his list of people that he wants to blame. And the government yesterday actually filed that they don't want Josh to be able to use the defense of it being someone else unless he has evidence. They filed a motion yesterday where they want to limit Josh Duggar's ability to blame a third party. This is funny. I mean, Remember how I've been saying to you that the shady ex-con has been this thing that's been happening all over the place and that Jim's been telling this to people? It's actually in this record, and it just tells me that the people that are telling me things are actually getting the right information on this case. And I just want to thank my sources for being so accurate. And it's interesting here because it says, the government anticipates that the defendant will attempt to introduce evidence suggesting that other individuals had access to his desktop computer at issue and therefore could have committed the offenses charged in the indictment. Any such evidence is nothing more than wishful speculation based on bare suspicion, which is inadmissible under legal precedent cited herein. So their argument here is that he filed a motion entitled Defendant's Motion to Dismiss for Government's Failure to Preserve Potentially Exculpatory Evidence. Therein, he identified 3 individuals and speculated that their cellular phones contained exculpatory evidence, which amounts to incriminating evidence against 3 individuals because they had access to wholesale motor cars. The 3 individuals were William Mize, who was witness number 1, Joshua Williams, who was witness number 2, and Randall Berry, who was witness number 3. So here are your witnesses: William Mize, Joshua Williams, and Randall Berry. So they want William Mize's bank records so they can exclude him. Joshua Williams, we're going to get there, and Randall Berry, okay? So on September 27th, they conducted a hearing and included in motions. At the onset of the hearing, the counsel for the defendant moved to withdraw the argument in his motion to dismiss with respect to the individual identified as Joshua Williams. Specifically, after the government brought certain information to his attention, defense counsel advised the court that he realized that he and one of the defendant's other attorneys represented Mr. Williams in April of 2019 in connection with a criminal matter that resulted in Mr. Williams being sentenced by Benton County Circuit Court judge to serve 45 days in county jail. Isn't it funny how Travis Story is always representing people that do really bad things, and he wanted to blame a shady ex-con that he literally represented, and he was putting in jail at the time that Josh's crimes were allegedly happening. You cannot make this up. The amount of mistakes that Travis Story makes is astronomical when you start looking at his history with defending Josh. He also pretended like he wasn't on ALB Investments as an officer. It's ridiculous. Travis Story for the win. He's always bringing comical fare for these cases. Anyways, I might not hire him if I were in Arkansas, but that's just my opinion. So anyways, they say that he was in jail at that time. So he was in custody from April 15th to May 28th. And based on Mr. Williams' incarceration during the time frame charged in the indictment, the defendants claim that some unidentified exculpatory evidence existed on his phone. That is evidence incriminating Mr. Williams and tending to prove that the defendant's innocence with respect to the indictment was meritless. The court granted the defense counsel's request to withdraw the portion of the defense motions to dismiss related to Williams. Okay? If you remember in Josh's motion, witness number 1 is the one that he identified as a person of interest, and they excluded him. During the hearing, they also presented evidence that the wholesale car records sworn and produced by the defendants, no other employees worked or were paid by Wholesale Motors during the time frame and charged, reflecting Matthew Waller, who worked there until the end of April, and Randall Berry, who was witness number 3, who received his first paycheck on May 31st for work completed during the week of May 24th through May 31st. At the close of the hearing, the defense argued that the cellular phones belonging to Mr. Berry and Mr. Mize might have contained some sort of exculpatory evidence during the time frame identified in the indictment, and the court denied this motion. After the hearing, they say that they contacted Mr. Berry, who confirmed that he did not start working at Wholesale Motor Cars until the end of May. He also informed law enforcement that after the execution of the search warrant at issue, the defendant closed his car dealership, but assisted him in getting a job at his brother's car lot where he still works today. The information has been provided to the defense in discovery, and the law enforcement determined that on May 15th, 2019, Mr. Mize, who was never an employee of Wholesale Motor Cars, was in Walmart located in Ozark, Missouri, approximately 120 miles away from Wholesale Motor Cars. This information has been provided to the defense in discovery. So this is why they want his bank records, because They say he was at Walmart in Missouri, and they need his bank records to prove that. And he was there on May 15th when some of the worst stuff was downloaded on Josh's computer. So if he is in Missouri, he can't be the one downloading it. And he was also never an employee. On or about October 5th, the government filed a motion requesting that the defendant provide a notice of any intended alibi defense pursuant to the federal rules of evidence. And defense counsel responded to the government via email stating that they do not anticipate advancing any alibi defense triggering discovery obligations. Consequently, this court entered an order finding the motion for it such as moot. At a September's motions hearing, the government presented evidence that on May 15th, 2019, at approximately 11:30 a.m., the Tor network was utilized on the HP computer to access CSAM. And they say that Mr. Mize, was in Walmart on the Ozarks 120 miles away when this was happening. They also say that the government is likewise aware that the defendant has made statements to potential witnesses that his current legal situation arose because he placed too much trust in felons or ex-convicts. Insert the shady ex-con. So basically what they're saying is they can introduce legal evidence to prove it was another person, but it has to have more than just a statement. They have to have evidence that they're connected. So they can introduce evidence, but they also have to have evidence that connects them sufficiently to this. So he can't just speculate that it was someone that he put too much trust in. He has to physically prove it wasn't him. And they say that when determining whether evidence of an alternative perpetrator should be admitted into trial, they have found that such evidence is relevant, but there must be evidence that there's a connection between the other perpetrators and the crime, and not mere speculation on the part of the defendant. So they're arguing that Josh has yet to provide any evidence for this, and so therefore they should not be able to use this defense. And they said it is not sufficient for the defendant merely to offer an unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. So they want him to be prohibited from advancing evidence of a third-party guilt with respect to the 3 individuals identified in his motions to dismiss, or claiming that some yet-to-be-identified perpetrator used his computer to download and view CP without setting forth an actual non-speculative nexus between the alleged perpetrator and the charged offenses. Indeed, as revealed during the prior hearing, the defendant's theory that one of the 3 individuals identified in his motion to dismiss might have used his computer to download and view child P was based on nothing more than rank speculation. The defense was actually in possession of information affirmatively establishing that one of these individuals was in jail and could have not possibly been the defendant's computer to download or view CP during the time frame. And that was only revealed as a result of the government's investigation in response to their conjecture that this individual might have it on his phone. Put simply, the mere fact that 3 individuals may have been present on the car lot prior to the execution of the search warrant, but outside of the time frame at issue, is insufficient to permit the defendant to advance a theory of a third-party guilt with respect to any of them. In fact, the presence at the car lot outside the time frame at issue in the indictment places them in the same category as any customer who visited the lot in 2019 or beyond, permitting the defendant to suggest at trial that one of these individuals or some other unidentified perpetrator committed these offenses absent far more substantial evidence that may very well be the defendant's sole possession to the extent such evidence exists at all, will serve to only confuse and mislead jurors with a parade of self-serving, speculative, ultimately irrelevant theories. For this reason, they want the government and the court to exclude third-party guilt evidence with respect to the 3 individuals herein. So this is interesting. They don't want Josh to be able to blame these 3 other people. How does Josh respond? Instead of talking about the defense, now he doesn't want the court to get access to his corporate records, which showed bank statements of who was paid on what dates and when they were paid. Because if we can prove that Randy wasn't working on the days in question, you can exclude Randy. So Josh doesn't want the corporate records that actually were used at the hearing to be used in order to prove their innocence. Again, another elephant in the room technicality. They said that Duggar objects to the attribution of any such records to Duggar. Instead, this court should require the government to limit any such testimony to state that such records were provided in response to a corporate summons or subpoena served on the city. So they're saying that Josh provided these records and they weren't provided accurately because he provided corporate records and it was Josh that provided them, not the corporation. So Josh wants to remove the evidence that shows that William was not there because his pay records don't show that he was there. He wants you to forget the elephant in the room, that Barry will testify and can testify that he didn't start working until the end of the May. Barry could submit his own pay stub if he wanted to, but they want you to say that they can't have access to his corporate statements because that will Barry. It'll exclude Matthew Waller. It'll exclude Williams. What's his name? Joshua Williams. You can't use Joshua Williams now because why? He was incarcerated, and William Mize, they say, was at Walmart in Missouri. And so now they're asking for the records, who is the person he's going to blame. And now you've got one person left that he is going to try to blame. One person and only one person. And the government says because none of these people were there, they don't get to just say it was one of these people unless they have concrete evidence that it was someone that was there. And there is no concrete evidence. And so therefore he can't just speculate. Jim Bob and Josh love to speculate and have been using this publicly with every single person. Isn't it interesting now that the government says you can't use that? We'll see what the judge rules on this. But that's what we have for now. William Mine's bank records are being subpoenaed, and if he can prove that he was at Walmart and he was actually in Missouri, Josh is going to be out of luck. All right, you guys, tell me what your thoughts are in the comments below. Elephant in the room.